afternoon, everyone, and welcome back to this week's episode of the Digital Law News produced by Anson Evaluate. I'm Amelia Davies, an apprentice solicitor at Digital Law, and I'm joined by my colleague Peter Wright. We're just going to be running through some news stories that have been coming up this week. So I'll pass over to Peter to introduce himself, and then we will get started.
Thanks, Amelia. So my name is Peter. I'm a solicitor and the managing director at Digital Law, and we've got some interesting stories from both home and abroad to go through this week. So I'll pass back to Amelia to kick us off.
Thanks, Peter. So we are starting over in the US. So there has been a data theft in the US, and it is going to be a criminal case. So Los Angeles County District Attorney George Garcon announced an arrest in connection with an investigation into the theft of personal data of election workers. So the CEO, Eugene Yu, was arrested on suspicion of theft of personal identifying information by investigators from the Los Angeles County District Attorney's Office. And the investigators also had seized hard drives and other digital evidence. And this was kind of under a 5-year contract, and they were supposed to be securely maintaining the data and ensuring that only US citizens could have access to this. However, it appears that this hasn't been the case. So I'll pass over to Peter to go into that in a bit more detail.
Thanks, Amelia. This is an absolutely fascinating story because we talked about data breaches in the US, I think, just last week, and very often what tends to happen is you may get, and if there is an issue, it's very often sort of enforcement via an organisation being dragged through the courts by a state attorney, as opposed to any sort of direct regulatory enforcement of the type that we get in Europe and the UK, where you get regulators turning around and saying, you've broken the law, we are going to fine you so many 100,000 or millions of pounds instead, or euros. And instead in the US, very often you get big corporations can sometimes delay and gum up the litigation process, so it can take years for any enforcement to take place. Because we're getting to the point now that some of the firms involved, particularly the tech companies from California, are simply too large and have greater resources than the state and federal government does. But this is a different approach to enforcement, and it's because of the serious nature of the breach, and also the fact that we have a cast iron contract. And not only is it a cast iron contract, it's a cast iron contract associated with data covering elections. Now, I think the first thing to make it clear here is that we are not talking about the personal data on the electoral roll in California. Rather, this is the computer system that is used to store the data of the people who administer the elections. So all of those poll volunteers who monitor the records, who send out guidance to voters beforehand, who arrange polling on the day, who handle the early voting, who handle the voting by mail. Or, none of these things happen by themselves, and there is a large infrastructure of staff employed by the Secretary of State, as well as, the Secretary of State in each state, along with large teams of volunteers who all need training, who all devote a lot of time to the way that these systems then operate. So it's data related to them that we're talking about, and it's sensitive data, their home addresses, contact information, and the contract in this instance with the IT platform made it very clear that this data, and let's face it, this is data of those who are either working for the state government or who are volunteering their time and support to the state government. That data wasn't supposed to leave the United States. And in this instance, it turns out that, in fact, the data was being stored on servers in the People's Republic of China. And not just that, the data was actually receiving support and updating from administrators based in China who, if they need to run an update or install, fix any bugs, they could go into the system and see all of this data, which is where it's a real problem, because as many of our listeners hopefully who use different systems may be familiar with, you can sometimes be operating with your system confidentially on a platform, but the company that provides that data can't actually see your confidential customer and client data. This is, for example, really important with law firms. We need to make sure that our clients' information cannot be seen by the people who are administering that for tech firms. So in this instance, key issue on electoral law, that data shouldn't leave the United States. That data shouldn't be shared with a third party that can view it. And then in this instance, the tech company has taken $2.9 million for a 5-year contract, but has then been found to have been operating the system in breach of that contract. So it's because we're looking at issues around electoral law and that data. And the fact that that was being sent off to China means we're looking at criminal sanction rather than, civil enforcement, which we might otherwise have expected. And it's also high profile. Don't forget there have been allegations raised with regards to the integrity and security of US elections in the past. Again, we aren't talking about data related to the electoral roll, i.e. the voters here, where it's data related to the staff. But in a narrative where we have the US midterm elections coming up fast on the rails in a few weeks' time, in November of 2022, it's not great that an issue like this has been identified. So that's another reason why I think the State Attorney's Office is taking the drastic steps that they are here. And I think several other states who also have contracts with this IT firm have also cancelled them as a result of the this ongoing criminal litigation and the arrest of the CEO. So it's not just California that's affected by this, it's several other states as well.
Thanks, Peter. I think if you're a regular listener as well, you'll be aware of the potential risk in sharing specific data like this with China. I believe we talked about this quite in depth when we went over the TikTok story. However, when sharing data with China, you are realistically inadvertently sharing this data with the Chinese government, because essentially they can turn around to a business and say, we want to know X, Y, and Z. You as a business, you're not going to turn around to your government and say, no, we're not going to do this because of the regime. I think it's specifically important to highlight this here when we're talking about the kind of shaky relationship that the US has with China as well. And I will pass to Peter to kind of finish this kind of thought for me.
No, those are really good points there, Amelia, and you highlight the fact that, yes, the situation with China has changed in recent years. So we've gone from the two aspects of that. I mean, for example, it's interesting that China's just had its parliamentary congress. I say parliament in the broadest possible sense of the word, more because of the sort of party congress, whereby President Xi has just taken his third successive term in office, and interestingly, his predecessor, Hu Jintao, was escorted out of the proceedings as this sort of third term was being authorised, and the new team that will be running China for the next term was put in place. The point here being that Hu Jintao was all about sort of opening up China, and it's sort of opening up more to the world compared to where China is now. But I raise this because on the back of that, you had things like the UK turning around and trying to lead a golden era of new relations with China. And very often contracts were signed. I mean, we had nuclear power stations and broadband networks being installed by the Chinese in the UK. And yet, a few years later, it's then got to the point that the UK National Cybersecurity Centre said, no, we need to have Huawei infrastructure ripped out of the UK's broadband network, which is slowing down the rolling out of high-speed broadband around the UK as a result. And then in this instance, we've had, clearly in the US a number of years ago, it probably wouldn't have been a problem if you had China involved in the infrastructure in this instance, but because of the deteriorating relationship with China and the fact that we know that these companies, if you're a company in China, the Chinese state can tap you on the shoulder and take a look at your data without the sort of oversights that you get in a G7 democracy. So, I mean, we have a lot of concerns, the European Union has a lot of concerns about data that ends up being moved and stored in servers in the US, but at least, the US government has to get warrants and do things before it looks at the data that someone like, say, AWS or Google store, in theory. But the point is that in China, it's a darn sight easier for the Chinese state to say, we want to look at this data. And that's why we've had problems in the last few years, of everyone from Zoom potentially storing their data on servers in China, which they got in trouble for in 2019 and 2020. And we've also then had issues like this, where it turns out that data was being stored on servers in China. When that decision was taken, it might not have been such a politically sensitive issue, but certainly it's ended up landing Interserve in this, it's ended up landing this company in America in a great deal of difficulties as a result. So Connect Corp, it could be that when this 5-year contract was brought in, they may have thought that having data stored in China wasn't such a problem. But I think if you are looking at your network infrastructure now, you should be avoiding, like the plague, having any of your infrastructure having anything to do with servers located in China because of issues like this that come up.
Thanks, Peter. So moving on to our next story. So this is a piece of ICO enforcement. So the ICO have fined Interverse Group Ltd, a Berkshire-based construction company, 4.4 million and that is because of a breach of data protection law, as they have failed to keep personal information on its staff secure. So the ICO found that the company failed to put appropriate security measures in place to prevent a cyber attack, which then enabled hackers to access personal data for up to 113,000 employees through a phishing email. So there's a fair amount to unpack here, and it's almost a story twofold, because at the end of this, Commissioner John Edwards is kind of setting out a lovely warning. So we'll start with the enforcement and then move on to this warning that John Edwards has spoken about.
Yes, so it's a fairly significant fine that's been applied here, £4.4 million, for failing to keep their staff personal data secure. And this is a frequent problem when it comes to making sure that different platforms are kept properly up to date. In this instance, it was with regards to making sure that software was being updated, patches were being applied, and that staff were receiving the right level of training around the use of data. In this instance, the ICO has said, look, you don't have the appropriate security measures in place to prevent a cyber attack, given that you are handling such a large volume of data. And we're talking about the data here of 113,000 employees. And it looks like it was just the sending of a phishing email that allowed this data to be compromised. And also it's the fact here that we're looking about a broad range of data, including not just names and addresses, it's national insurance numbers, it's bank account details, so all of those sort codes and account numbers that you need in order to run the payroll. And then we've got the special category data, so things like ethnic origin, religious affiliation, details of disabilities, sexual orientation, health information with regards to medical conditions, medical records, leaves of absence, all that sort of stuff has potentially been compromised. And where we then get that, of course, it's a matter then of applying appropriate enforcement. So, and I think, because sometimes you get a data breach where it's, say, a comparatively small amount of data, but it's very sensitive, i.e. that sensitive data we just talked about. But in this instance, it is sensitive data, and it's a high volume of it, more than 100,000 records. So that's why we're looking at such a comparatively high fine for a company here with 4.4 million. And it's important that you get reasonable, proportionate enforcement like this on a regular basis, because in 2018, one of the biggest responses I very often heard from different companies was, do we really have to carry out all of these measures that GDPR requires? Because we don't think we do, and we don't think they'll actually apply these fines. It's just designed to scare us. Well, this is the proof in the pudding. That is not the case. The ICO will investigate, it will fine, and it will use its powers to make multi-million-pound fines where it finds significant breaches have taken place.
I think it's also important to mention here that this is not just information on current employees. There's also information that has been stored with former employees. And then there's the question that's raised is this data still kind of relevant? Are these employees, if they worked for the company 20 years ago, is it still necessary to be keeping this data on them? This isn't specifically explored in the ICO fine, but it does kind of leave subject to speculation. Should this company have still kept the members of staff kind of on file and the information that goes along with that.
Exactly, Amelia. So it's the fact that should they have been retaining this data in the way that they were for such a long period of time, I think that is something that the ICO is really hammering home here, because the number of times we end up, speaking to our clients, helping them with privacy policies and data protection compliance, and we have to make them realise that you cannot retain data indefinitely. You're only supposed to retain data for as long as is necessary. And even then it might be that you retain some employee data, but you wouldn't necessarily retain all of that employee data. So would you need all of that, those sensitive bits of information which you talked about? Would you necessarily need to retain all of that about all of your employees? That's the question here. So it's the fact that then when there isn't proper data retention in place, and then the fact that when issues are identified, and in this instance, the company actually had an antivirus system in place that quarantined the malware that apparently entered the system via a phishing email. So you've got staff not recognizing a phishing email when they see it, which is a problem. They then end up having malware installed. And then even though that this suspicious activity is reported by their internal antivirus security system, it reports the fact we've got suspicious activity here, and they don't do anything to actually investigate what's happened. And if they had done, they would have found that there was an attacker in there that had access to the company's system. And that attacker had access to 283 different systems and 16 different accounts across those systems. So that's why the breach is so wide-ranging. And it's these sort of fundamental breaches of what the ICO really sees as fairly basic practice that we've got to find that's so high. So we've got data being retained for too long. We've got employees who don't know basic standards in terms of spotting a threat when they see one and not knowing what to do when they do see that threat. And then we've got a system that doesn't then act to the report of suspicious activity being received. Now, we've seen large pieces of enforcement before over things like failing to install updates when you are supposed to in a reasonable length of time. In this instance, they're told, you've got suspicious activity here, you need to investigate this, and it simply didn't happen. And that's where we therefore get the ICO finding that, look, you failed to follow up here on the alert that you've received. You've not acted properly. Your training aren't properly, your staff aren't receiving proper training. You haven't got the right level of risk assessments in place, and you're handling large volumes of personal data. So this is the sort of stuff that you should be on top of as a matter of course. It's almost like as well, when we're looking at the fact here that we're talking about a company called Interserve, that's main bread and butter business is technology, that in effect they're saying, look, you really should have been on top of this, and there really isn't any excuse, hence the large fine.
So that leads us very nicely on to kind of the second part of this enforcement. So John Edwards, the UK Information Commissioner, has given companies quite a big warning here. So if your business doesn't regularly monitor for suspicious activity in its systems, fails to act on warnings, or doesn't update software and fails to provide training to staff, you can expect a similar fine from my office. And I feel like that speaks volumes here, because he is pointing out essentially everything that has gone wrong with Interverse there, and also highlighting the fact that they are going to be cracking down on things like training and making sure that there are the correct systems in place. Because I think you and I have spoken before when we discussed Tucker's LLP, we mentioned that it is very straightforward and easy to simply update patches on your PC and any software you've got, and that's a fairly quick and easy fix to problems which may mitigate any kind of attacks or actors kind of coming in and into your systems. However, here you can clearly see that John Edwards is saying this should be kind of regular, this should not be going unnoticed, and truthfully they're going to be cracking down on this, as we've already seen.
Exactly. And I mean, this is actually highlighting a lot of the things that, surprise, surprise, this is what we end up working with our clients on. We end up very often being asked to go in, do a baseline assessment, identify the issue, and I hate to say it, but very often the issues that we identify are usually broadly the same. lack of data retention policies, lack of those policies being actually enacted within the organisation, a lack of training, a lack of applying that training, sometimes a lack of effective training. So if it's just death by PowerPoint or some tedious click through these screens exercise, you aren't going to engage people. So we do a lot of delivering workshops and actually making people think about what we're asking them to do and making sure it's properly tailored and focused to the role that they are carrying out. So, you know, they shouldn't be just seeing something that's by the numbers. You have to say, well, given your level of expertise and seniority, these are the sorts of things that we think you will be carrying out on a day-to-day basis, and this is what you need to be doing as part of your day-to-day roles and responsibilities. So it's tightening up on all these sorts of things, and here's the clear wording here from John Edwards to say, this is what we expect from you. If you're not doing it, there will be consequences.
Another point to mention is the fact as well, if you are able to demonstrate that you are complying with the UK GDPR insofar as possible for you to do so, which could include keeping records of employee training and assessments and records of data protection impact assessments, then there is a possibility here that it may lessen the fine or the type of enforcement that the ICO have given you, because you could be seen to at least be trying to demonstrate compliance from kind of your standpoint.
Exactly right, Amelia. It comes down to having the documentation in place to demonstrate compliance. If you've got that, if you've got a plan in place and you're working towards compliance, you've got something to be able to say to the ICO, look, we are doing all we can be reasonably expected to do. What they do not like is when they go into an organisation and they see complacency and they see people who are not taking any measures and don't have a plan to improve their standards, who think, oh, we're perfectly fine, our standards are good, nothing to worry about here. And without fail, the ICO very quickly realises that data protection, privacy, security is not a priority within that organisation, hasn't got the right resources, and they're making it clear where you are doing that, and we expect that you should be taking it seriously. We will therefore issue a fine.
Thanks, Peter. So moving on to our next story. So this is looking at the Product Security and Telecommunications Infrastructure Bill. So that leads nicely on to your previous mention of Huawei and kind of taking this infrastructure out. So this bill essentially looks to make a provision about the security of internet connectable products and products capable of connecting to other products, to make provisions in electronic communications and basically make clear what should and shouldn't be done. And so this has been kind of in the pipeline for quite a long time now. I think it was the beginning of 2021. However, this bill has now reached the consideration of amendment stage, which is one of the final stages of kind of the bill going through Parliament. And so it's very interesting here, as Lindsay Cameron has mentioned this in her speech, speaking at the Singapore International Cyber Security Week. And this is kind of looking at how the Internet of Things are the future, and we need to be making sure that there are procedures and statutory instruments in place to make sure that we are using these products in the best way, and also preventing cyber attacks and from state actors from kind of using these in any sort of malicious and nefarious ways.
Exactly. I mean, this is a nice example, actually, that despite some of the chaos in British politics of the last couple of months, things are still happening. And this is actually a quite crucial piece of legislation because, as you say, it's talking about the technology of the present and the future. So much technology now is smart enabled. We're used to things like the smart TV, but of course now we have our smart toothbrushes, the smart fridge that works out that you are running out of milk and places an order with the supermarket. We are increasingly, at the time of the energy crisis now, people are installing smart switches and smart hubs at home to try and limit the amount of energy that's being wasted. So you can have an app on your phone and you can automatically see what plugs are on, what plugs are off. You know, the days when it could be, oh, I think I've left something on. Well, now you can switch it off remotely using your app. But all of this technology involves items being connected to the internet, and that level of connectivity can open things up to a risk of being compromised. I did attend an event a couple of months back with a number of data scientists there who'd carried out analyses on a number of items of home equipment that were being used. Basically smart equipment that would be used day to day. So everything from a smart speaker to, you know, smart lights, smart toothbrush, all this sort of stuff. And it turned out that, despite the fact the product could have come from a provider in Europe or America, if you plug this thing in and you started using it, in something like 75% of cases, data was then being squirreled away and going off to China. Item hadn't come from China, but it seems to be that it must have used chips or hardware or technology of some sort, and very often it seems that the actual fact that this data was going to China may not have been something that the actual provider of the product even knew or was aware of. But that kind of highlights the issue and the risk around the use of connected smart technology, and therefore this piece of legislation does try and put certain minimum standards and provisions in place regarding this equipment and the infrastructure that it relies on for connected purposes. So let's see what happens then when this becomes law. The interesting thing is, I think it is the sort of piece of legislation that will require constant amendment to make sure it stays actually relevant, given the way that this technology is moving forward at a considerable pace in terms of its application and use.
Exactly, and I think as well, for me, I think I read a study a few months back in relation to how a light bulb could be turned into a listening device, something as simple as a smart light bulb. I think what they eventually did is they changed the sound waves or something to do with the light bulb so that it could essentially listen in on your conversations. And that, in regards to kind of how smart something is on the spectrum, you think, oh, a smart light bulb, you know, what's the harm in that? And compared to, say, a smart speaker or a smart TV, but it can be kind of items and products that are just that simple, that can be essentially hacked to listen into conversations. If you think about, okay, you could be in a secure government building or a secure government facility using a smart light bulb, and lo and behold, suddenly that information is leaked and people know about it when they shouldn't. Exactly,
and that also highlights the we've talked about the risk before from technology, like, for example, connect smart vacuum cleaners. So these little cleaners that go around cleaning the floor when you're out, they can be hacked. They do not have a microphone on them, but same thing, sound waves. They use sound waves to make sure they don't hit the furniture, so they can be hacked, and then the hackers have been able to apply an algorithm to those sound waves to then work out what is being said, so they can listen in. And this happens with a range. I mean, who would have thought, as you say, Amelia, that, you know, smart lights would end up using sound waves in that way? But it turns out that the hackers are able to sort of reverse engineer and listen in on a conversation even without the presence of a sort of mic or conventional audio equipment on that piece of technology. So, you know, it just shows the potentially immense vulnerabilities as we end up looking at the proliferation of this sort of smart connected technology around our homes and workplaces.
Thanks, Peter. So moving on to our final story of today. So not a week goes by where we don't list kind of one of the big companies and what they've done wrong. And you won't be surprised to hear WhatsApp in the news this week. So WhatsApp went down for users across the UK this morning of the 25th of October, with tens of thousands of people reporting being unable to send or receive messages. One of the sites that have been tracking the outages said more than 69,000 reports of problems had been submitted at around 8:28 a.m. this morning. And so initially on the surface, you think, oh, crikey, WhatsApp's down, great, what am I going to do now? However, I think digging beneath the surface here, why has WhatsApp gone down? What's made it go down? And what information could have perhaps been taken whilst it was down?
Indeed. I mean, it's interesting how much people rely on WhatsApp day to day. I mean, I think very often we're more used in the UK to using WhatsApp for social reasons. So, you know, social groups to stay in touch with colleagues, family, friends, people that you're on a stag weekend on. You know, that's what you tend to get WhatsApp used for. But around the world, it's used a lot for businesses, for deliveries, for communication as well. So when it goes down, there is a real impact on businesses' communication and livelihoods. And in this instance, we've got a period of downtime with tens of thousands of reported problems, and probably far more people actually affected who just didn't report the issue. There was the joke I heard this morning that perhaps it was coincidental that WhatsApp had gone down at the same time that Rishi Sunak was preparing to take office, and that if there was one way that if you wanted to crush dissent and stop people plotting against you, you'd take WhatsApp down, because WhatsApp is so popular amongst MPs. They have these huge WhatsApp groups that allows them to communicate and discuss different things. And of course, in the last few months, they've used it to plot and bring down two prime ministers. So if you wanted to stifle that, you'd take WhatsApp down. We are not making any links there between those two things taking place, but it just shows how heavily used WhatsApp now is in so many different fields. And I think the other thing to point out here is that it really shouldn't be. We are forever saying to our clients, do not use WhatsApp for business purposes. So even though it is end-to-end encrypted, it is not designed for and should not be used for business purposes, because it is not possible to necessarily be clear who it is you are communicating with. Have you got the right individual? Is it a spam account? On these big discussion groups, large numbers of people end up being added by other users, so sometimes you can't be entirely sure who it is who is seeing the communication. And it's because of the fairly leaky way that WhatsApp operates in that way that even though it is end-to-end encrypted, it isn't necessarily secure. Plus, your message, if you do have a WhatsApp discussions, is end-to-end encrypted. Yes, it's encrypted on the user's devices, but it is also stored on servers, and those servers can be located outside of the European Union and are in the control of a company that can then be subject to warrants from the US security services to look at the data on there. So, if you are a highly regulated organization operating in a profession like law or accounting or banking and finance or medicine, you really should not be using WhatsApp for those purposes. And that applies not just to external communication, but also internal communication. There are other, more secure, better platforms available. And consequently, this is the second major time that WhatsApp's gone down within the last 12 months as well. So I'd say there are also more reliable platforms out there as well.
Thanks, Peter. So that was our last news story of today. A big thank you to Anson Evaluate for helping to produce this webinar, and we will be back this week. And just a reminder, these episodes are available from our website, our YouTube channel, and Spotify and Apple Music, as well as Amazon Music as well. And thank you for listening, and we hope to see you again next week.